Who came up with this? I know you read a lot of books big like this. I read in law myself. But who comes with these things? Who came up with these theories? Please.
And make dealings with each other, and they believe that there's something that is somehow called the first treaty that is about 2,000 years old, that was carved in stone already between two villages. So I think it just developed, and there wasn't one single intervention.
By who?
Invention.
By who?
By the people.
The people?
Yeah.
Which people? Yeah, this is interesting.
The people, well,
so
usually
you mean like the whole community came around somewhere and then...
Usually the rulers will speak for the community in some way. Yeah.
Oh, okay. So the rulers, normally they are representative of something, isn't it?
They should be.
Yeah, they're representatives of something, and that something would be interests.
Yeah.
And therefore, interests normally shape how the law is advanced. And therefore, if that premise is correct, it therefore means that perhaps maybe international law may not necessarily cover everybody else's interests. Think about it for a second. It may not, in all cases, cover everyone's interests. More so when it comes to international economic law. And I want to take you a little bit aback so that we could have appreciation as to how the international economic law, somehow as we have it, particularly after the 1945, came about. Most of African countries, except for Ethiopia, were still under colonization after the Second World War. When you look at the history books that narrate the conversations that took place in the 1940s, black and white, you see them in black and white, you'll not find any African country that had actually had a moment to sit, not even Ethiopia, to sit and craft the current rules that we have today. Because the rules we have today, whether it be in the area of investment, whether it be in the area of finance, whether it be in the area of monetary policy and in the area of trade, those rules, when they were created, none of African countries were at the table. And that's the reality. Again, when you read the history of international economic law, you'd also find out that even countries that were at the table at the time, they did not have the political economy, they did not have the political power to influence those rules in their direction. Here I'm talking about, you have the Cubas of this world, you had many other developing countries, the Chinese part of them were there, and several other countries, even the European countries themselves. Okay, so the point that I'm trying to drive at you, remember that everything is contextual. So is the law. What was happening in Europe in the 1940s? It was decimated. No infrastructure, decimated. And the country that had the sound economic system at the time was the United States of America. And it is for that reason then you have the creation of the World Bank, you had the creation of the IMF. Why? To actually go and support the rebuilding of Europe. The rules that govern the IMF, the rules that govern the World Bank were modeled around the reconstruction of Europe at the time. And of course, it meant that the Americans were giving loans to the Europeans. And I'm bringing you back to the 1940s to come and talk about trade, because by the time they said, let's wake up to the reality that if countries trade together, there will be less incentives amongst them to enter into wars. Why? Because if your business is exporting products to country B, you coming from country A, the likelihood of the two countries engaging in war, that will be very much minimized, because you are mutually benefiting one from the other. And then they said, well, let's actually come and create these international rules. Again, I'm going to the point that the law always has context. But you can imagine if rules were to be created, Europe is decimated. The industry in Europe is done and dusted because of the World War. Who would actually have the interest to export products? It would be the United States of America, because they had the industrial base. And the rest of Europe was decimated. That's the point. So if now you say, let's create rules that can allow for exportation of goods across borders, those rules will likely be modeled after the interests of the United States, the businesses in the United States. And I want to take it further and say, at international economic law, mostly the rules are modeled after what I call the business models of specific companies. Now, you sit at the table, and I can assure you, all my life I've been a negotiator until I went into academia for 7 years, and here I am with the AfCFTA Secretariat. I had the pleasure of sitting and negotiating the economic partnership agreements at the level of SADC EU. I've sat with the Americans, SACU, and I can name them. At the World Trade Organization, I had the pleasure. For 4 years of my life, I was the chief negotiator of African countries. What you consider law, it doesn't actually transpire at the table. What transpires at the table is which businesses would you want to have export their products to country A, country B, country Z? What sort of protections do those businesses need in order for their products to make it to country A, country B, country Z? Once you have captured the business model of your own companies at home, you go and then you create rules that can protect that business model. And of course, after that, it's a question of convincing other negotiating parties to accept those rules. Are we together? I am not saying you don't have the principles of international law. You have them. Most favored nation principle, all these beautiful principles, they stay. But the moment you come to the level of the rules now, that's why I started off by asking you, what is public international law? In particular, what is international economic law? It's like I have your attention, isn't it? Yes, please say.
Depends much on the interest only. So individual interest, company's interest matters the most into defining or redefining the meaning of international law.
Absolutely. That's what I'm saying.
Okay.
That's what I'm saying. And I'm going to say things that you don't want to hear as well. I was a young diplomat, and I just joined the Ministry of Foreign Affairs. I'm from Lesotho. And I was told, and I think I was probably 2-3 weeks in the job, I was told, you go and pick up some representative of the World Bank from the airport, and they were to meet with the Minister of Finance and the Governor of the Central Bank. I was in my early 20s, just like some of you. I looked exactly like some of you here. So, I mean, if there's anything that we hate in foreign affairs is doing protocol. That's, getting people and telling them where to sit, that was our job. I mean, we are bound to do that. I picked this young man. I'm saying a young man because when I got there, I found out that the guy was probably in his mid-30s. So he was very young. Take him on, and then we go to meet with the governor of the central bank. My governor of the central bank had actually had a very illustrious career. This is the guy who went to Princeton. He knows it all, right? So we respect this guy. Sits there, and I could not believe that I'm in the presence of these high and mighty individuals, and the managers of the bank are there. So I sit in there. What struck me was the respect that they were giving to this 35-year-old guy, almost taking everything that this young man is saying. So I was shocked. And my family, we were in politics, so, and I don't know, we've been in the struggle, so I could not understand what's going on. At 6 p.m., we go and meet with the Minister of Finance, who used to be one of the managing directors at the World Bank. So you have these guys who've been there. And the conversation, and it's unrelated, but I want to make a point. A conversation was that the Minister of Finance said, because we had a very high incidence of HIV infections, and it takes a lot of money now to manage the disease and this virus and help the people to make their living worthwhile. And the minister said, well, we have decided to have a budget line that will be funded by the money collected as duties by the government. And we're going to put it in this particular budget for the coming year. I'm with a young man. You know what he said? He said, Honorable Minister, I don't think it will be allowable for you to use your own money to pay for that particular line. We'd rather find you, and this is, I think, 2006, if not 2005. We will find you some loan, whether concessional or a grant, but so I want you to understand that the extent to which international law applies, it is also within some of the contracts that you sign as a country. And therefore, what is basically happening here is you have an institution that has higher level of authority than your parliament. And this is what I'm trying to say to you. And I'll repeat that again. You sign on to international treaties. In this case, Lesotho is a party to the instruments of the World Bank, and the World Bank in that case could actually dictate to the country on how to actually make use of its own money because of the commitment it took. Then I said to myself, and I went to my father, who was in politics, and I don't think he was as advanced as I don't think his thinking was as advanced in understanding what's happening. And he was a member of parliament at the time. I said to him, I came from this meeting and I don't understand what had just happened. Does it mean that you as a member of parliament, you cannot make a determination as to what should be the governing rules of this country because someone else elsewhere has the capability to dictate what goes into the national budget, and you can't change that. What is international economic law? And I'm saying this because most of you in here are Africans, and you need to understand how things work. Now, these are decisions that those who got independence made. Because you cannot say the same thing of a country like China. You cannot say the same thing of a country like India. They used to be in the same position, but with economic rise and economic power, they cannot be dictated to as to what should be their economic policy. So, I'm saying all these things in light of the AfCFTA. We sat down, myself and a gentleman called Professor Milako, we crafted the rules. when we were crafting the rules, the basis of the AfCFTA had to be the World Trade Organization agreements, meaning over 40 odd African countries had already signed on to the World Trade Organization as members, and therefore the rules in the World Trade Organization could not be defied by the AfCFTA agreement. Are we together? But again, what are these rules that we're talking about? I spent 8 years of my life in Geneva, and I told you 4 of them I was negotiating on behalf of the continent, plus my boss, Wamkele Mene, the Secretary General of the AfCFTA. Now, if you have a moment someday, and if you're interested in international economic law, I challenge you to go and look at all the proposals of African countries in the World Trade Organization. Go and look at all of them. Review them, and you're going to find something in there. African countries have always been fighting against the rules of the WTO. Not the principles, the rules. MFN, everybody agrees to it. Consensus, everybody agrees to it. Fair dispute settlement, everybody agrees to it. And I want to give you another example about this issue. I had the pleasure at the World Trade Organization level of being the chairperson of 2 committees. A committee on trade-related investment measures and a committee on import licensing. And I want to go back to where our conversation started. When you look at the rules under the WTO agreement on trade-related investment measures, there are things that developed countries, policies that they applied that developing countries, in particular countries like ours, are no longer allowed to apply. That's why I asked you, what is public international law? For example, I sat and presided over a meeting, and the issue was Nigeria. Nigeria, one of the states that has these oil fields, they introduced a law. You know, Nigeria is runs a federal system, isn't it? So this state introduces a law that for those oil companies that are, getting oil in Nigeria, they were now obliged to use certain services and procure certain goods from Nigerian businesses. And they passed that law in Nigeria. The United States, Japan, the European Union, a couple of more developed countries that are in this oil sector, they raised a query to my committee. It was brought to me as the chairperson of the committee to say that Nigeria has breached its obligation in the trade-related investment measures agreement. And the obligation was no country is allowed to pursue local content. You cannot oblige investors to procure goods from your own domestic companies. You are not allowed to do that. Goods and services. Please, the way you're looking at me, don't get angry. We're talking about international law, no? Hello? Are we talking about international economic law? And the AfCFTA is built on the WTO, right? So it means under the AfCFTA you're not allowed to offer local content? Hello? Are we together on this? I hope you understand where I'm coming from. Myself, I studied this thing. By the way, I did my degree at Trapka here. There's very institution I ended up teaching at, right? And they taught us, great professors who taught us there. Van de Bosch, one of the great, those are the guys who taught us. And they taught us about these things. Import licensing, not allowed. You cannot, import licensing, not allowed. And I had a case that had to do with Brazil when I was chairing the committee on import licensing. During the World Cup, a year before the World Cup in Brazil, the Brazilians, they instituted import licensing measures to limit the importation of certain telecommunication equipment so that they force the broadcasters from elsewhere in the world to use the Brazilian broadcasting networks. Are we together? And they knew, the Brazilians, they came to me to say, Makong, you know what, we're doing this, and we know that by the time these guys come to the committee, we would have had the World Cup. And we will reverse the measure after the World Cup. What am I saying to you? I'm telling you of the international economic law. Why would a country push for others to agree to not have local content? Of course, if I have businesses in a given sector, I don't want them to be facing competition by the export destinations. So what do? I'll come up with a rule to say no import licensing because I don't want competition. So, when I'm teaching international economic law, I normally say there's nothing called international economic law in this sense, because you advance your economic interests. Unless you think that I'm in a sense against any other country that has come up with the law, I always say, if I was an American, I would do exactly the same. I would do exactly the same. Why? It's businesses, it's money, it's jobs that I'm protecting. And therefore, I create rules in that particular sense. So I thought that I should first start by giving you this broad overview of how this thing works in international economic law, and I may not probably go deeper into some of the relationships between the three legs of the pot. One, the trade policy, the monetary policy, as well as the finance aspect of these policies. They are one and the same thing. So you cannot separate them, but maybe that's for another day. The AfCFTA. The AfCFTA is born out of several decisions, and you'll have my slides. For example, in 2012, and I was in Accra at the time, before the decision was taken, we had a ministerial meeting there that adopted a decision to establish the AfCFTA. And then there was also in 2015 the formal launch of the AfCFTA negotiations. In 2018, there was also the signature of the AfCFTA agreement. 2019, the agreement entered into force and there were 22 ratifications. 2019 also, there was the launch of the operational phase of the agreement, and then 2021, the official trading under the AfCFTA started. And thereafter, there were several other legal instruments that were created. I wish you could see this slide, but it's not possible. There are two forms, or rather two phases of the AfCFTA. We had phase one, and under phase one, there was a creation or a negotiation of the protocol on trade in goods. Protocol on trade in goods. It lays out rules concerning applicable duties or not, so that when you export the products from Tanzania to Kenya, for example, they will attract no duty, zero. Trade agreements have a positive import substitution effect, meaning you open up your market, and the expectation is if this particular microphone, for it to be imported into Tanzania, you have to pay 50% of the value of this. Let's assume it is $10. So it means you have to add $5 more, right? Now, under the AfCFTA, we bring it to zero. Now, the rationale is if this microphone is zero, the investors will find it worthy of coming to invest in Tanzania or wherever else in the continent to manufacture these microphones because it is now cheaper. If any of the African countries are producing these microphones, we are now supposed to be having these microphones being sold all over Africa at a cheaper price than getting them from elsewhere in the world, because from elsewhere in the world, they will still attract 50% charge. So if you import this microphone, it will be $15, but if you import it from places outside of Africa, it will be $15. But if you import it from an African country, it will be zero. That's the whole idea, and then we create rules around it. The trade in goods also rules on sanitary and phytosanitary measures. These are rules that apply on agricultural products, meaning the vegetables, your animal products, and all of that, so that we have similar rules. Because rules that are dissimilar, they basically create problems for businesses. If Tanzania has different rules from Nigeria, from Egypt, from Algeria, Morocco, I don't know, Lesotho, whoever, imagine if you're a business and now you have to comply with all these rules and you have a production line. One particular country may have certain labeling requirements. Maybe in Tanzania you say our products have to be labeled in Swahili only, for example. Others, the products have to be labeled in French. Imagine if now you have to have this business and you need to export products to different countries and there is no symmetry in as far as the rules are concerned. You see how expensive it would be, even if this microphone is at zero, simple labeling requirements, just to label products. The requirements on labeling, some countries will say, we want the font to be this big. Others will say, we want the font to be this small. You see how simple things can actually make it difficult? How many machinery would you buy in order to make sure that you meet the certain font requirements of a given product? You get the point? They will tell you that the moisture content of a product should be at this level. The reason why sometimes it's difficult for you to export your corn to a neighboring country is a simple matter of moisture content. They take your corn, they basically do the tests, and they look at the moisture in that content. Sorry, the moisture content in that product. Are we together? So we are trying to make sure, so the rules go into making sure that we make that easier. And therefore, we would have this import substitution effect. Positive import substitution effect. This is what the agreement does, and there are many other aspects that you have. They have what they call technical barriers to trade. There is trade facilitation, customs and trade facilitation. Also, you'll find the rules in there. So that was agreed. Also, as part of the phase one, there was also an agreement on trade in services. Trade in services. There are 12 services sector in there, and they've been negotiating rules on 5 of those sectors, and the negotiations on the 7 sectors will start very soon. Maybe these are things you're not familiar with. I know you very much know about human rights law. It makes security and all that. But for anybody who flew into Arusha, or anybody who, even if you came by road, I don't know, from Kenya or from wherever, there are rules that apply in as far as your movement from one country to the other is concerned. And those rules will apply to you as a natural person. They also apply to the companies. What we call, as you know, you're lawyers, so you know this, the juridical being imposed. For each person who disembarks on that plane, there are certain fees that are impayable to the government. Now, the AfCFTA, and this is a service, transport service, and the AfCFTA is saying we need to have rules, and we open up that market, do away with the fees and many other technical barriers that come along with the sector of civil aviation. Are we together? So these are the things that we are negotiating. As I told you, I lived in Europe for a couple of years. I used to drive from Geneva. I go to Brussels, I go to Milan driving. Nobody is stopping me. No policeman, no immigration. It's in the Schengen area. No problem whatsoever. Open borders. Why? Because the Europeans under the European Union negotiated trade agreements that opened up these particular markets. But for you, if you go through Namanga there, you know that you're going to spend a bit of some time. And I always give this example many years ago, because when I was staying here, there was no one-stop border post. That building you have in Namanga is called one-stop border post. The way a one-stop border post is supposed to work is that once you give your passport to the Kenyan side or whichever way you're coming through, let's assume they're from Tanzania, you're going to Kenya. Once you have given your passport to the colleagues, the immigration officials in the Tanzanian side, you don't have to repeat the same cycle the other side, on the Kenyan side. Once you have declared your car, you submitted your registration card, have you seen how it works there? Because I live this thing, right? You submit your registration card. Have you seen the chassis number of a car? Those numbers, you put it, you lodge it with the customs official in Tanzania and pray to God that it's not an old man who's not used to computer, because if it's an old man, they're going to begin to punch each number, each key, a minute for each. A minute for each. By the time they get, I don't know whether it's a string of 19 or however numbers, you've lost 20 minutes, somebody just trying to enter the chassis number of the car. And then you go to the Kenyan side, the same process. But technically, we know that the similar way you can send your email from one person to the other, data can be exchanged like that. But no, you go to the Kenyan side, you also have that document, they begin to do the same process again. Not in Europe. You don't even have to show your registration card. You just drive. This is what we're trying to achieve at the level of the AfCFTA. Not there, but what I'm saying is that there is a protocol on trade in services. It's also a protocol on prevention of disputes. So you may be interested in it. And the strange thing about it is, I'm talking about this while being here in the African court. When we were conceptualizing and designing the AfCFTA, before I even joined the African Union, the issue was, can the African court be the court to resolve the disputes under the AfCFTA? And we discovered that no, it's not possible, because the mandate of the court is limited. It does not extend to economic affairs. And if you wanted it to extend to the economic affairs, now you'd have to go and then revise the statute establishing the court. So again, we did not believe that the court would have the competence, because you need the people that are the economic lawyers, people from that field. And it's a very specialized area. So we said, it's okay. What we do now is to come up and mirror the system of the World Trade Organization, which is the WTO dispute settlement. When you look at the AfCFTA dispute settlement system, it mirrors the WTO dispute settlement system. I was not involved in that, because you can imagine, I had been in Geneva for 8 years, and we've been looking into several matters, problems that the WTO dispute settlement system had. And I certainly couldn't be one of those people who will replicate the same system in Africa. I wouldn't. I think there's probably only one country, I don't know whether it was Tunisia and Morocco, I know they had a dispute. The dispute in terms of, if you talk about access to justice, as you said, it is so expensive, none of us can use that system. The WTO. But we have actually adopted more or less the same system here. So we'll see who will have the capability to make use of the AfCFTA dispute settlement system. Because it's expensive. At the WTO, way, way, way too expensive for us to be able to use it. Let me give you this anecdote. There was a case at the WTO on cotton. And the case was brought by Brazil. We have 4 countries in Africa. We call them C4. They produce the margins of production when it comes to cotton are very high. Your Burkina Faso, your Mali, your Benin, Chad, those guys produce huge levels of cotton. Because they are one of the highest producers of cotton, if somebody is breaking the rules under the World Trade Organization, these are the countries that were supposed to raise a dispute against whoever country it is. And we knew that the United States was over-subsidizing its cotton producers for many years. And Brazil said, well, we'll take the US to task. The question is, why didn't the C4 take the US to task? Brazil took them to task, the US, and they won the case, by the way. They won the case against the United States. Are we together? It is also a question of whether you have the economic and political power to use the system. So the access to justice also depends on your economic power and your political power. You tell me, how do you take a country like Lesotho, you take the US to dispute settlement when the US probably covers 30% of your health budget? How do you do that? You don't have the economic power to do so. Are we together? So, we are trying to create this system that can allow us to make use of our own rules. Of course, like I said, I have misgivings about our protocol because it's very difficult to use. We used to have what at the time we were saying that the WTO dispute settlement system has to be reformed to allow countries to be able to retaliate. And the point was that even if you use the system, let's say Lesotho, somehow we have a case against the US and we win against the US. What happens if the US doesn't abide by the outcome of the rulings? What happens? How do you, and you're allowed to retaliate, you can go and retaliate. So let's assume the US doesn't abide by the ruling, which is against its interests, and therefore Lesotho goes to the dispute settlement to say they're not abiding by the ruling provided, please give us the power to retaliate against the US. So you tell me, how is Lesotho going to retaliate against the US? Brazil retaliated against the US. The US said, no, we cannot change the rules because they have been passed by the Congress. The WTO rules and the WTO dispute settlement body cannot have supremacy over our Congress. But I thought that you as a student of international law, you know that once you actually sign onto an international treaty and all instruments, they take precedence over your national. He said, no, the WTO cannot take precedence over the decisions of the Congress. So then Brazil said, okay, we go to WTO to ask for the right to retaliate, and they got the right to retaliate. And they said, well, we know how we are going to retaliate. We are going to breach the intellectual property rights of the US rights holders. They knew where to hit the US at the time. The US said, okay. And then the US is giving them hundreds of millions every year. Every year, they give them hundreds of millions. Why can't Burkina Faso and all these other guys do the same? My own country, in the context of the AfCFTA, let's bring it home. We import 80% of our produce from South Africa. Small country. 80%. So let's say Lesotho then has a case against South Africa. And we get the right to retaliate against South Africa. How am I going to retaliate on someone of whom I depend, like 80% of everything that I import is from them? Where am I going to retaliate? Because my retaliation will be self-infliction of wounds. It will be shooting myself in the foot. It's about economic, the usage of rules depend on your economic power. Are we together? So that's the part of the AfCFTA. All I wanted to say is that we do have these legal instruments. It also has the phase 2 legal instruments. We have negotiated, our member states, they have negotiated the protocol on digital trade, and we are very proud of that. And I had the pleasure of sitting down and holding the pen with a colleague of mine, Dr. Chidede, to come up with the AfCFTA protocol on digital trade, as well as the annexes to that protocol. Very proud. It's one of a kind in the world. I think we only are surpassed by the European Union in terms of the quality of rules, not because we are saying it, those who have done the assessment of that particular instrument. There's also an instrument on competition policy, protocol on instrument policy, or on competition policy, I beg your pardon, and there's a protocol on investment, there's a protocol on intellectual property rights, and then there's a protocol on women and youth in trade, the only of a kind that exists in the world. Those rules are there, and these have been created by the Africans themselves. The first phase of these negotiations, that is trade in goods, trade in services, and dispute settlement, they have been adopted and they have been ratified by about 50 countries now. These other protocols, phase 2 protocols, they are yet to be ratified by members, but they have been adopted by the African Union Assembly. Now they're waiting ratification by our member states. That would be very difficult because they are far-reaching in terms of the rules and the reforms that would have to be undertaken. So that is the AfCFTA, and it has several objectives. One is to create a single market for goods and services facilitated by movement of persons, to foster economic integration in the continent to deepen it, to create liberalized markets for goods and services, and you can find this in Article 3 of the agreement. It also has principles, and again, these principles, you'll find them in Article 5 of the agreement. Now, this is where legally the AfCFTA becomes a little complex. And I'll pick not all of the principles, but some of the principles. For example, one of the principles is that the regional economic communities, your EAC, your SADC, your ECOWAS, IGAT, you name them, they are to be the building blocks of the AfCFTA. But what does that mean? To say that these legal instruments are supposed to be the building blocks of the AfCFTA. Think about it and we'll revisit this particular point. One of the principles is the principle of variable geometry. The AfCFTA is governed by the principle of variable geometry, meaning that there is a recognition that down the road there may be countries that want to expand the canvas of liberalization, of market opening, and maybe not all African countries would want to do the same. Just like you have it in the EAC. It's a principle that you can have countries that are willing to move ahead while others may not be ready to do so. There is also a principle of the preservation of the acquis. The preservation of the acquis. Now I'm talking to lawyers. So are you saying that as you develop the rules under the AfCFTA, they must not be worse off relative to the rules that have been created at the regional level? Meaning there should not be rules that are rec minus under the AfCFTA. So you preserve that which has been created in terms of the advancement at the level of the regs. So these are some of the principles, and they have significant legal consequences. And if we have time, would be able to speak to them. Decisions are to be made by consensus. So that's a very important aspect. Okay. Does anybody have a reflection, a question? Yes, please.
Thank you very much. Thank you very much. I mean, this is what you can say. It's Aristotle would call this is an intellectual appetite that cannot be satisfied, or intellectual thirst that cannot be quenched. And then now you have aroused it even more. I have several questions and comments, but I will start with one so that I give others a chance also. I would like to maybe look at one of the missing links in your African regional integration and free trade, if I look at the EU and the history of the European Union, maybe personalities like Robert Schuman, you know, because we are only looking at actors like, I like when you, for instance, when you started with a question on what is international law, what is international economic law, you know, trade law and so forth. In the EU, one of the personalities that has shaped the EU to where it is today is Robert Schuman. He was just a businessman. Of course, he was influential among the politicians, but he wasn't a political leader himself. Robert Schuman was an individual businessman who believed that Europe one day would come to be where it is today. So I think in many African parts, for us, we don't go, let's at the level of AU, let's go at the level of the RECs, regional economic communities. Look at SADC. You know, we leave everything in the hands of politicians, and as individuals, we have failed to influence shaping the vision and the destination of SADC. Yeah. And now in connection with this, I wanted to raise a question on the shortcomings and advantages of the variable geometry, which some people would also term as CAO, condition of the willing, in the sense that why can't we for a while strike it out, we kick it out and just say, let us all follow these rules until when we reach that level where we have implemented most of these, that's when we can allow the collision of the willing or variable geometry. I say this with a practical example. When the East African community, which is where we are sitting here now, agreed that they are going to trade as a bloc, then the US approached them, and even in the EU, Tanzania refused because they said that we are going to be disadvantaged. Kenya and other Uganda and so forth went to say, okay, the collision of the willing, you know. But the same goods that came under variable geometry found their way into Tanzania. Well, Tanzania refused. So these are the things that make us close borders. Because you say, okay, I've heard that you have imported the goods that you rejected. You have imported them. They are in Kenya. So you are going to close the border. You know. So if we get rid of this variable geometry for a while, we suspend it, then we are going to encourage more free border trading because we have trust in each other that whatever lands in the East African community is what we have agreed upon. I would like to stop there. Thank you.
No, thanks a lot. I know that I kind of like spoke like a politician when I started, but I would want us to reflect on the reality of how trade actually takes place. And by this, I mean, first, this issue of the coalition of the willing, the principle of variable geometry, in reality, what exactly do they mean? I know there is a discussion which becomes political, you know, where we say them and us. And here we are referring to China, we are referring to Europe, we are referring to North America as them. And then we have us. But what if, and by the way, this doesn't, what if we say our conceptualization of trade liberalization, our conceptualization of entering into agreements with third countries, non-African countries, should actually not be ideological, but it should be economical. By that I mean, for example, I don't know if you are aware that the European region has around $400 billion worth of investment in Africa. Of course, there's colonial legacy to that. But largely speaking, $400 billion worth of investment in Africa. China has about 40 billion, only 10% of that. So, if you say that, and you didn't say that, I'm just giving a perspective. if the question is them against us, who is them? Because for any integration, economic integration to be viable, you need transfer of technology. And transfer of technology is equivalent to investments, foreign direct investment. When you say Tanzania and Kenya, who exactly are you talking about? Now, is anybody from Kenya here? Yeah, Kenya, right. I don't know. Are you familiar with trade? Maybe not. Really? Yeah, what are the main products that you produce in Kenya destined for Europe? Tea, coffee, flowers. Absolutely. Thank you very much. So, who owns those businesses in Kenya producing tea, coffee, and flowers? Oh, foreign companies. I hope you heard that. I hope you heard that. So, but you do have Kenyans that are producing their own tea, right? Ah, okay. And others are into producing flowers. How did they get the capability to produce their own tea and flowers? What I'm trying to say here is, you begin to see the trickling down of the transfer of technology. Let's take it to China. China of the 1980s, those guys were poor. I don't know, they'll be on those bicycles. I don't know if you've seen the pictures of China in the 1980s. What happened? They said, we are going to take a different course. We are opening up the markets. The Americans, the Europeans, they saw huge market in terms of the consumers in China, in terms of the low cost of production in China. They began to bring their investments into China. But what has happened over time? Within less than 30 years, we begin to see China replicating the same technologies and advancing them even further. The idea that trade is seen as an ideological matter. By the way, we can take you back before we even had cars moving around. The issue of the transfer of technology was happening in our communities. This is why you would have the merchants selling salt. Those that were closer by the sea, they will sell salt to those in the hinterland, and then they enter into barter trade. It's always been an exchange of knowledge between communities, between societies. This is how it's always been. And therefore, in my view, I know there's the first vice president of Zambia said something striking. And if you think about it from an ideological point of view, political point of view, it made sense, because he said, you better be watchful that the colonization is going, but it's going to come back in a form of foreign direct investment. Exactly, right? So you can take that headline and run with it. But maybe foreign direct investment is not so bad if you do it the way the Chinese have done it, the way the Indians are doing it now. We are watching the Indians doing it now. You jump on a flight. There was a time, I'm old enough to remember these things, and maybe some of you may not. There was a time when if you jump into any flight, probably half of that flight will be the Chinese. Back in the days, half of them, they were moving all over Africa. When China began to make a lot of money, they began to actually go to different other places. Today it's India. You cannot jump into a flight going to Zambia. Probably 75% of folks in the flight are from India. What's going on? I mean, just think about it. In our case, if you jump on any flight, if from Accra, when I jump onto Ethiopian Air, going to Addis Ababa, over 75% of the flight, it's small-scale traders, I don't know, mostly from Ghana, from other places in West Africa. Where are they going? China. To buy goods from China, and sell in the domestic market. But the Indians that are going to Zambia, they are moving from India to Zambia to establish businesses. So I think that the way we understand international trade, it fundamentally has to shift a little bit. The issue is, how are you harvesting the transfer of technology and then beginning to build the small companies, and hopefully, God willing, in the future there will be big companies. Europe is in trouble now because it is declining in terms of the level of productivity and innovation. You live, sir, you live in Europe. So in Germany, by the way, what is happening to VW? What's happening to Peugeot in France? You see the point? Huge outlays in terms of people losing jobs in Germany because they adopted the American model of, bundling the whole stock market principles against the German principles, where the main thing was to make sure that they become innovative. But then the CEOs of those big companies entered into these notions of stocks, buybacks, and all that, instead of investing money into productivity. Now, VW is running to Germany I beg your pardon. VW is running to China today to be able to incorporate the Chinese technology in its softwares and all that, because they are that advanced. Yes.
Because it means that the agricultural products have to come on the EU market. So France and Netherlands are objecting, saying that they will bring diseases and so forth. But we know the real reason. The real reason is that products from Argentina, Brazil don't cost that much. So they are going to wipe out most of these countries that depend on the agriculture sector.
Yep.
Like Netherlands and France, for instance. They don't have so many minerals and so forth. So they depend on agricultural products for their subsistence. But Germany, for industry to survive, they need the Latin American market. Yeah, so the EU is still in negotiations. Come what may, one day they have to agree that Germany has to export some of its products to Latin America, and Latin America has to export the agricultural products to European market.
Yep. So this is the reality of the rules. You see, the circumstances that get countries to create or not create rules is reality. And where is Africa? I wanted to come to one point. And it stems from what we said. Has anybody heard what is the level of trade between Africa and the rest of the world? Have you ever heard that figure? The share of Africa in global trade is less than 3%, meaning the products we produce in this continent and export them to international markets, including minerals and what have you, relative to what the world produces, it's less than 3%. If you remove the oil from Nigeria, from Angola, the gold, these natural minerals, it's, I don't know, 0.000 something. We are almost not trading with the rest of the world. Those flowers, they become nothing, monetary. If you go to Village Market here, there's a supermarket here, it's called Village Market. If you go in there, just take a tour. I'm a student of trade, so this is what I do. Just take a tour, look at the products in there, look at where they come from. Go to the food products, whether it be snacks, even vegetables sometimes, certain fruits. In Tanzania, it's a little bit on vegetables, it's fine, right? But certain fruits you'd find, if fruits and vegetables for Tanzania is like Eden, right? You have everything here. In Tanzania, if you are hungry, it is because you really want to be hungry, because food is everywhere. Yeah, it's hunger by choice here. Yeah. But if you look at all other products in there, they are all important. Can you believe it that Africa has 60% of global uncultivated arable land, the land that can be used to produce food? We have 60% of global uncultivated arable land. But we actually import 60% of what we eat from other countries. And I always say it's oxymoronic. You have land to grow food, but you're importing food from elsewhere. Let me go back to that point. That 3% we are talking about, how many African companies are actually responsible for the 3%? Dangote is coming up, but how many I'm talking about indigenous African companies that are responsible for that 3%. When I talk to the Europeans, and I fight with them all the time, we have discussions, and I said to them, but why? It doesn't make sense to me, because your companies are the ones that are exporting the 3%. The flower industry, those companies from the Netherlands are the ones that are responsible for the investment in Kenya, the British in tea. We know. No, not, what's your name, say? Not Sydney and Daughters Company. Now, intra-Africa trade amongst ourselves, what's the percentage? They've put it at 16%. To say the trade we conduct amongst ourselves as the continent, the level of it is 16%. And again, I talked to my European friends and I said to them, but tell me, who owns Vodacom? Who owns Safaricom? Sydney. Yeah, and then who owns the rest? It's British, right? Safaricom is British. They say MTN is South African until you discover that it is traded in the London Stock Exchange. So the point here being that even the 16% intra-Africa trade, it is also the investments that are coming from outside. Not that it is wrong to have investments from outside. No, that's not what I'm saying. Because I believe investments are important for the purposes of transfer of technology. If you get proper policies back at home like the Chinese did, then you can leverage those investments for the purposes of harnessing transfer of technology. Can you believe that we are talking about international law? Why? Because all these elements we are talking about, they are codified in these rules. We need a predictable market for investors. That's what I forgot to mention this. That's why one of the protocols we have is a protocol on investment that sets out rules that countries must abide by when it comes to investment in the continent. You have all of those here. So in the future, if you're a young lawyer, I think that there's a future for the economic lawyers, in the sense that as long as we go ahead trading deeply amongst ourselves as a continent, then there's going to be better prospects. Not everybody can be a human rights lawyer. I think that is saturated. Not unless God has anointed you to be this stellar lawyer, human rights lawyer. I think we have enough now. In fact, this profession of ours, it is one of those, it's like a dinosaur, it's like it's going to fade with time because of AI. Believe me, it is true. Believe me, it is true. I'm studying AI now. I'm studying this thing, not the chat part where you just get everything. No. Proper prompting and building the skills for things that I would want this thing to perform. And I look at it and I said, wow, so this thing can do something that 5 of my colleagues can do. Already I'm using it. Can you imagine? I'm telling you. And the AfCFTA we have under the protocol on digital trade, we have an annex on emerging technologies where we encourage the adoption of these technologies for the purposes of enhancing productivity. I'm telling you, those things that our professors are teaching us, I'm sorry. I studied hard. When I was doing my doctorate, man, it was very hard. But right now, if I was to do my doctorate, to be honest with you, no, I'm being honest, because if I know what I'm looking for, I don't have to go through the library and then flip in this book and that book. This thing can be able to take me to the relevant books I need to read. And if I want to read certain sections, it will take me to those sections. I don't have to read the whole thing. Of course, some people have to read the whole thing. I'm not saying you shouldn't, but I'm just saying that when I remember there was a book I was reading, this thing I don't know. And what I was looking for was in the last chapter. And I had gone through I'm like, this is way, and I'm like, if I had this tool, I would have just jumped into that thing, and then I would know where to find it. Of course, it makes people lazy thinkers, but it depends on how you want to use it. Anyway, so my point about this is that we have the AfCFTA, but yes, please.
Hello? Yes. Sorry. I have a reflection and a question.
Sure.
Mine is a reflection and a question. But you've mentioned many.
You're using AI. Go ahead.
You're mentioning many of the things that I wanted to talk about. So just my point of reflection is, as Africa, we have to be selfish. That's the main word that I want to say. We have to be selfish. When you started out, or when I came in and you were speaking, you spoke about how Africa wasn't at the table when many of these rules were being written. And we have to be cognizant of the fact that we weren't there. But what are we doing now to be selfish enough to say that we shall write rules that play in our favor and work for us? The question I'll put to you is, what can we do as Africa to make it work? But I'll answer that by saying we need to be selfish. I'll give a few pointers. You spoke about the advent of AI we have right now. Africa has, I think, the youngest population in the world today. Maybe my statistics, but often I think we have the youngest population in the world. But what percentage of our young population is being taught to be productive and useful in the age of AI? So it means with the education systems we have today in Africa, we are lagging behind the rest of the world. So by the time a young Tanzanian, Ugandan, Kenyan, Nigerian, whatever comes up, they're already lagging behind the rest of the world. Meaning they will not be as efficient, employable, and very useful to help Africa grow. You mentioned the arable land we have as Africa compared to the rest of the world. And we're still importing food. But some of these are policies that I think have been implemented or forced on us not to allow us to grow our food. The advent of GMOs now, whereby someone will plant whatever they plant, it grows once, and you have to go back to the market to buy the seed. That means the scientists that created these from Europe and from America and from all over the world, the Western world, still benefit, keeping you even poorer. Yet your soil is very fertile, very arable, but they're making sure that they control the seeds. Locally, historically, you throw some seed in the ground, it grows, and you can get food.
Okay.
The economies today in Africa, we don't control our banking, so the source of financing is very hard for us. You spoke about a good point. The Chinese model of allowing FDI to come, but let it also be beneficial to us. You gave a very good example. Most of the companies we have, even those that we think are African, Africa only holds a small percentage. We're very small shareholders in many of those companies, meaning we don't keep enough money at home to allow our economies to grow, our businessmen and our equivalent of the Jeff Bezos and Mark Zuckerberg.
Can I ask you this question? What's the role of the law in that?
The law should be able to put in place, I believe, structures that allow us as Africans.
But who creates the law?
We create the law. But still, as I'll put this question to us all of here, we create the law, but some of the people that are creating the law or we give influence have influence from the West. So they
I
don't
understand.
create.
Can I just say this? And I understand about the political economy aspects of international systems. If you were Chinese, right? If you were Chinese, and you have people that need employment, what sort of policies would you adopt? I mean, so China, Africa.
Yes.
What will be your perception about Africa?
If I was Chinese,
You know, let me put it differently. When we talk about Africa and the rest of the world, it is true that as His Excellency the President of Ghana has talked about their reparations and all of that, there's been a lot of injustices towards Africa, and they continue. It's true. Yet we are yet to have a movement by the Africans ourselves towards what you're talking about. Now, I wouldn't want this to be a discussion about political economy, but there are many other things that I can mention. And I want you to fully understand how the system works. And at least from my limited way of understanding things, how things are the way they are. And I'll speak about my institution, the African Union. Here. Who do you think funds the African Union? You don't have to answer that question. The funding of the African Union, member states put in less than 2% of the budget. So imagine if you're in the African court and then you're saying 2% of the budget of the institution is coming from African countries. So where is the other money coming from? You understand the dynamic? Do you think that it would be in the interests of countries that benefit from Africa to have Africa come out as a competitor? If today Europe and the United States are at it, like fighting on a day-to-day basis, economically fighting, the US and Europe are today at an economic war. Today. The European Union has rules that govern big platforms like Google, for example. They're saying you cannot siphon data of the European citizens and use it for this and for that. You cannot breach our competition rules. And I think, I don't know how many billions of dollars that they've been slapping in terms of fees over companies like Google, like Meta, and others. And it's in the public sphere. It's on the news. If now you go and then you check the European Union, imposition of sanctions, I don't know, fees over Google and American companies, and the response of the American government, just read that. I'm not talking about things that I'm making up. Just read that. And what I'm saying to you in this respect is to say that if you have an economic interest in a given market. If you think about not as countries, but you think like business people. Remember I was saying, when you think about the international economic law, think about the businesses behind that. Because the rules are crafted to favor the viability of businesses in certain foreign markets. This is what this is about. So tell me, if you are a government and then your businesses are finding problems in a third country market, what are you going to do? Isn't it that you pull all the levers you can to still make sure that that company does have viability in that market? The issue for us is we politicize economic issues. Yes, politics are always there, but we overly politicize. But I can also say to you, how come that Dangote is building this big company that he's put together? Where do you think he's getting his loans? Do you think that that man has his own money? His pockets are so full. He has his own bank. He just gets money and then he establishes an oil plant. Where do you think he gets his money? Is it that simplistic? No. He gets loans from where? From African banks? Oh, so African bank. Which bank? AfDB. Oh, okay. Which other bank? AfRexim Bank. Oh, AfRexim Bank. So these are African. Yes, they are Africans. Who owns them? Yeah, AfRexim is owned by African countries. But where does AfRexim Bank get its own money? Isn't it that it goes to the money markets? Where are the money markets? In Europe? Yes. In Asia? Yes. In North America? Yes. You see how the world works? That's why I'm saying this idea of them against us, this is the narrative part. So someone can come here and I don't want to mention names of respected people that you watch on Facebook. They can come, Africa this, African Union that, African, and I'm listening and I said, yes, they have a point. It is true, they have a point. But the reality is, for you to get there, you need to work. There's something that you need to do to get there. And it is understanding how the world operates. You can't wake up in the morning and then say, I'm going to pull up the plug. You can't. If you are rational about, didn't China show us how it's done? They didn't go out there shouting and shouting and shouting. No, they didn't shout. They said they did their own assessment. Okay, so which sectors? No, the most critical sector is electronics. Okay, where do we start in electronics? Light manufacturing. Okay, assembly. They start doing assembly. Remember, we used to think that the Chinese products were not the best of quality products. They started there. The next thing, they go to a higher level of manufacturing, and now they said, oh, by the way, we can do it by ourselves. We can build electric vehicles by ourselves. The Americans kicked them out of the chips market. They said, oh, what are we going to do? They didn't scramble. They said, let's put money and invest in manufacturing of chips. Today, Huawei and those other Chinese companies are at a certain mid-level of production of their own Chinese chips. If it becomes political, it becomes emotional, you don't want to go anywhere. And I listen to people talk about this all the time, but go and talk to people that are doing business. Those are the guys who will tell you what is needed for them to upscale their businesses. Can you protect them? Yes. They are trade instruments. We call them trade defense instruments, where you can protect the local companies, whether it's foreign investors that are operating in your market. Remember, they're bringing you employment. In China, they made sure that they had deals and contracts with foreign companies to transfer technology to the Chinese. They have contracts like that. You get the point? So it shouldn't be, in my view, something that becomes emotive. I attend a lot of these seminars and forums and people, and I can understand the anger to say we can do better, and I agree. But how do you start? What if we first go to Namanga and say, how come that the test results, my brother talked about SADC, how come that the test results of a product in Zambia may not be admissible in Nigeria? What if we have mutual recognition agreements between Zambia and Nigeria. You see how minute this is. But I can choose to jump in my mind and go to say, no, let's kick everybody out, blah, 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 blah. You see what I mean? But I can also say, what is it that I can do today? Low-hanging fruit, okay, we're having mutual recognition arrangement with Nigeria. The goods begin to move. The businesses begin to say, so it means that I can invest into other products, manufacturing, that will benefit from the same mutual recognition arrangement because this thing is locked in? Yes. Okay. Now, you see, you're hiring more people. You're beginning to bring in more machinery, new technologies, new skills. The next thing, a Nigerian business person would want to partner with a Zambian business person. Oh, no, it's a merger between the two companies. They enter into a joint venture. You see how businesses work? Why is it that these businesses are viable in Europe? Because they reduced the barriers. That is why you're having French companies that are in partnerships and in joint ventures with the German companies, with the Belgians. You see what I mean? Because they had to work on things that they can reduce as barriers and actually eliminate some of the barriers. So for me, that's my preference. You get the point. You know, I see you're young. You can see a beautiful model online and you say, that's my wife. But I tell you, that model may be so far away. But maybe there's somebody still beautiful around the city. There may be a model nearby. So it's things, you know, I don't know if you guys will read. There's this book that I read many years ago by Stephen Covey. He says there are two concentric cycles in life. There's an inner cycle and then the outer cycle. The more you focus on the outer cycle, the more you lose control. Because those are the things that you don't have control over. But if you focus on things that you have control over, that's how you make steady progress. So sometimes I see theories and we make things over complex. Add a lot of complexity on it. This AfCFTA is going to work if we begin to pick the pieces when it comes to the small and medium enterprises. Because in this continent, that 3%, that 16% worth of trade, these are guys that have a lot of exemptions in terms of taxes. You think that the Coca-Cola pays the same taxes as Mamamboga down the road? The small shop somewhere where TRA is going. Every day TRA is going. The taxes. You think that they do the same thing for these big mining companies? They have exemptions. In fact, when you see governments building infrastructure and whatever, it's the taxes from the small and medium enterprises. The micro and small medium enterprise. That's where the money is. If you are a government employee, you are being paid by the small and medium enterprises. Because that's the mainstay of the economy. So you focus on those, making sure that you open borders for them, small and medium enterprises, trading across borders. Jobs are being created. That's what we're trying to do with AfCFTA. I'm told that it's time for you to stretch a bit. It looks like this discussion is very tense. So you need to stretch a bit, and I'll give it to my brother here. And then the next time we'll try to wrap it up.
Okay. So thank you very much, Prof. We have 10 minutes of the break, and then when we come back, we'll come and wrap it up. Thank you very much.
I'm trying to be sensible in that controversy. So it's very easy to point things that are very far away. Very easy. And I did a paper recently. It's not published. I have it in my computer there. And I have a concern. And of course, I should have said when I started, everything that I'm saying it in my personal capacity. I'm not representing the African Union or the AfCFTA Secretariat where I work. We talked about the AfCFTA, and I think it's a brilliant legal instrument. In my description, It is an instrument that comes close to being a customs union, but not a customs union, because a customs union is an economic regime of which countries to that union have exactly the same import duties that apply against products from third countries. So the AfCFTA, in as far trade in goods is concerned, it doesn't do that. You can have your own import duties on products from the US, maybe as Tanzania, and Algeria can have their own, different. So it's not like the EAC. However, the AfCFTA at the same time comes very close to being a common market, at least in as far as the rules of the AfCFTA are concerned. It smells and looks like a common market, whereby rules and regulations of countries are more or less the same. Of course, countries are yet to ratify, meaning take those legal instruments through the national domestic processes. They are yet to ratify the protocol on digital, the protocol on women and youth in trade, the protocol on investment, the protocol on intellectual property rights, as well as the protocol on competition. They are yet to take them through the national legislative processes. Once they have done so, majority of the rules in those domains will likely be more or less something that looks like a common market, because they cannot legislate downwards. They cannot come up with rules that are against or rules that go in contradiction to what they would have adopted in their national systems. So if you have a certain rules on investment, I know I heard that somebody is going to talk about investment. How I wish I would be here, because I used to manage that file at the AfCFTA Secretariat. So I like hearing what people have to say about these things. So there's a floor below which you cannot go. You can only have better rules, not worse off. So this is the way these rules have been crafted. At the same time, there isn't any perfect legal instrument, and the AfCFTA is none of that. You are lawyers, so I would want you to reflect on the mess the African Union is in. The African Union is in a mess when it comes to its legal construct. It has a lot of problems. And I think it's good for you to think about this. We have several legal instruments in the African Union. And the question is, what is the governance framework of those legal instruments? We have the Constitutive Act of the African Union, right? It lays the fundamental rules. You know, one of the provisions in the Constitutive Act is that there has to be the ring fencing of the sovereignty of countries. Hello? One of the primary principles and rules in the Constitutive Act of the African Union is that we need to preserve the sovereignty of member states of the African Union. So, how do you equate the notion of the preservation of sovereignty of member states vis-a-vis the creation of a single market? Meaning, you are governed by the same rules. Are you saying that countries will have some sort of an opt-out where they can say, well, now this goes too far, I'm maintaining my sovereignty? As a principle, up there, as a principle. It means that we are not moving towards creating one continental, single regulatory system, in as far as that particular provision is concerned. Because you can invoke that principle to justify whatever derogation perhaps you may want to have. So I leave it to legal scholars. I'm not saying I have not gone deep into this, but I smell trouble in the sense that the Constitutive Act, being the constitution of the African Union, is saying you can preserve the sovereignty of countries. But for all intents and purposes, the trade agreements, they precisely do away with the preservation of your sovereignty. When I'm in class and in West Africa, I would have come and said at this moment, hello, and someone from Liberia will say, hello, the other side. Right? So there are fundamental legal issues that we need to study in as far as this matter is concerned. So I'm not going to go through all of my slides. So let me see. Yeah. Maybe I should forget about the slides. That's the first point that I want to raise. Earlier this week, I was in Addis Ababa. Sorry, last week, late last week, and I might actually go back there. But maybe let me not talk about it. Yeah, maybe. Before coming here, I was looking at the different legal instruments of the African Union. Different legal instruments of the African Union. There is an entity that deals with energy matters. There are entities that deal with free movement of persons. There are entities that deal with phytosanitary measures. There are entities that deal with data governance within the African Union. I mean, I can go through the list. I can go through the list. All those entities are founded at law, meaning there is a decision somewhere adopted by the heads of states to create those entities. It's not just a decision for creation of a given body. That decision will also outline the mandate as to what that body is supposed to do. That decision represents a commitment, an obligation that members of the African Union have taken, in as far as that matter is concerned. Are we together? The question that I would like you to think about is, to what extent do the instruments, legal instruments of the African Union interoperate? Are they interoperable? Are they coherent? Are the instruments of the African Union coherent? Let me take you back so that you would hopefully, oh, I forgot I have this. I don't know, it's a little bit, you may not see very well. You may not see very well. These are the legal instruments of the AfCFTA. And what I am communicating to you is that there is also other entities within the African Union, and there's also other rules, including fully fleshed statutes of the African Union in some of these areas, covering these areas. Have you ever heard of single African air transport? What do they call it? SATAM. There's an instrument where countries have signed onto to say there's got to be free, we got to advance to have single African civil aviation market. Have you ever heard of an instrument, namely Free Movement of Persons Protocol? Have you ever heard of that? What is it about? Free movement of persons. It's about free movement of persons, isn't it? Okay. What if I tell you that under the AfCFTA, in particular under the Protocol on Trade and Services, which covers 12 services sector, from business services, transport, including civil aviation and what have you. All of those, that particular protocol has a provision for free movement of persons. Also, and it is administered by the AfCFTA where I work. The free movement of persons, it is governed by another department in the African Union. And it's a protocol. What if I tell you that under the AfCFTA, we have the protocol on digital trade, and it has an annex to it. That annex is on digital identities. And under that annex, it also provides for free movement of business persons, natural and business persons. In fact, that protocol, yours truly here, was holding the pen with a friend of mine. We came up with this idea that we need to create the African AfCFTA digital identity. Hello. Coherence of laws. You can look into the question of the conflict of laws in the African Union, and you will find it. There is an instrument in the African Union on data governance. I forget the name of it. There is a provision in there that directly contradicts another provision in the protocol on digital trade. Directly. So, same member states, in different configurations, but same member states can come up with legal instruments that are conflicting one against the other. By the way, this is how the system goes. I feel my chest being a bit tight. You know, at my age, you could even have a heart attack when you feel a test. But it's stressing me. How do you, this is how the process goes. So, under the AfCFTA, countries come, they normally ask us to draft the first legal instrument before they negotiate. They look at it, and then they negotiate. Their role is to make sure that they don't agree to rules that for them to implement at the national level, there will be a conflict. So you can't have Lesotho negotiating a protocol on digital trade, the annex on digital identity, conflicting with another protocol that the same country negotiated. In reality, this is what is happening. Let's assume that the member states are not paying their due diligence on these matters. And then look at the African Union. Within the African Union, we have a committee of member states. It's called the Specialized Technical Committee on Justice and Legal Affairs. That committee, whenever time there is an instrument that is negotiated, that instrument has to go through legal scrubbing. Are we together? The first step is that it goes through legal scrubbing. Member states sit, they look at that instruments, and these are folks from the ministries of justice and from the Attorney General's office. They look at the legal instrument to make sure that this thing, it is actually coherent, it is okay, it is legally sound, it is not conflicting with other instruments of the African Union. But guess what? I don't think we need a guess. Really don't think so. Why? Because you still have legal instruments that are conflicting one against the other. I'm not saying it's a problem that is pervasive, but it's a problem that emerges in several areas. Not that it's so bad that everything is conflicting, but in certain key areas, you are beginning to see those conflicts. And because of the institutional framework of the African Union, there's even a threat for more conflicts down the road. Because you have institutions that are actually having mandate to do the same thing. Are we together? I don't know what people who's going to teach you are going to say about the African Union. I work for one. But you have the right to know about some of the challenges that we're having. Now, just pause and think about it. Why is this so? Let me go back to how I started. Could it be possible that there are countries who would say, you know what, I committed on this and I cannot jump out of it. Let me go and undo it elsewhere. The answer is yes. The answer is yes. So you end up having a bifurcated system. A system that gives people options on what to do or what not to do. In the European Union, they have a mechanism where they have jurists who sit and then they make sure that whenever time you have a legal instrument, they go through all of them vis-a-vis the rest of what had been agreed to make sure that there is no contradiction. In fact, that starts early on in the negotiations. Their legal counsel will be seated there in the podium. You know, we like seated there. Have you seen? It's nice to sit there, right? Yeah, pictures there, I don't know, and then you post it on your Facebook and what have you. Yeah, the guy has arrived. Seated there. No, don't just sit there with purpose. Sit there with purpose. So if you have legal counsel in the European Union, they will be in a position to have analyzed every legal instrument against any related instrument of the Union. And they will be able to advise accordingly to say, no, what you're saying, actually in another legal instrument, it has already been covered, and actually what is being proposed is against that. Now, it's for you as member states to decide whether you want to revoke what you had agreed on before and introduce a new thing, or you want to retain what you had already in place. The biggest challenge we have, therefore, in the African Union is the issue of the inconsistencies, number one, the inconsistencies between the union's legal instruments, and then we have the issues concerning incoherences between the different legal instruments, and then we also have the conflicts, outright conflicts between the different legal instruments of the Union. Big challenge. I close that chapter. How many minutes do I have, my brother? It's done. Can I close with this? And I know that you want to go. Even me, I want to go. But let me close by saying this. The trade-related legal framework of the African Union, including the AfCFTA, it is founded on the World Trade Organization agreements, at least in as far as the World Trade Organization does have a certain level of coverage of same subject matter that is covered under the AfCFTA. So, for example, the WTO does not cover digital trade. So that means the digital trade component of the AfCFTA is not based on the WTO. The WTO doesn't have rules on competition policy. It doesn't have rules on investment. It doesn't have rules on women and youth. So those legal instruments that are not part and parcel of the WTO, they are not therefore based on the WTO law. That's the reality. But the rest, trade in goods, trade in services, based on the WTO law. Again, I did another assessment. When I have sleepless nights, I write. So I'm there, and my family is here in Accra. Sorry, here in, I even think I'm in Accra. Can you believe it? My family is here in Tanzania, and I'm taking them to Accra. So I'm alone there, and I'm hearing mosquitoes in the night. I wake up, I begin to write. So I did a paper again, not published, there in my computer, on the challenges that are arising in as far as the World Trade Organization is concerned. Why is this important? And I want to give you two main examples. One, it has to do with the AfCFTA. The AfCFTA has an annex on trade facilitation. These are rules. Those rules are based on the WTO Trade Facilitation Agreement. The WTO has an agreement called Trade Facilitation Agreement, okay? The AfCFTA also came up with its own rules on trade facilitation. So that means the WTO trade facilitation rules are supposed to be the floor. They're supposed to be the minimum standards. Meaning the AfCFTA trade facilitation rules are not supposed to be what we call WTO trade facilitation minors. If you have a binding commitment under the WTO in a given area, you cannot have a best endeavor provision in the AfCFTA. You are lawyers, right? And you know best endeavor, it means it's not binding. So you can't have a binding provision and then have an optional provision. If the WTO provision is binding, the AfCFTA should be binding as well. You see, you get the point? Guess what? We actually have provisions in the AfCFTA Trade Facilitation Agreement that are actually best endeavor, optional. So already there is an inconsistency between parts of the AfCFTA rules and the WTO rules. Are we together? So there's an issue there. And I've only looked at it many years ago when I was teaching. I looked at this particular problem. Did a paper and all that. The second and the last thing. I told you I spent 8 years of my life working on the WTO. Can you imagine? 8 years of my life. When the negotiations were high, in 4 of those 8 years, I was the Lesotho, a small country, right? Can you imagine? We as Lesotho were the chief negotiators of Africa. Doing miracles there. Small country. Alone. I was alone. I had an intern. Alone. Everything. You do everything. You do everything. The basis and the ground, and here I'm talking about the rules. The rules, the basis of which the AfCFTA is based, are under severe attack. Those rules, as we speak today, they are in ICU. You know ICU? At the hospital. Yes. I think they are moving towards a coma. What do I mean? The key principle that is foundational to the operation of the World Trade System, which is based on the World Trade Organization rules. It is the principle of non-discrimination. You've heard of that principle? The principle of non-discrimination. If I made a commitment that this microphone will attract 0 duties, and this is under the WTO, for all countries in the world who export this microphone into my country, they will attract 0 duties. That's it. Non-discrimination. That's why you have the principle of most favored nation principle. We know that principle, right? There is also another principle in the WTO. It is called national treatment. National treatment. It is part of non-discrimination principle. Now, this microphone, it has entered into my country. A supermarket, now they display the microphone in their shelves. There is another company that is producing the microphones in my own country. The principle of non-discrimination says, national treatment, I beg your pardon, national treatment says, the way you treat the microphone that has entered into your market, into your commerce, should be the same way you treat the microphone produced by your own nationals. Non-discrimination at the border, MFN. Non-discrimination internally within your market, national treatment. It must get the same national treatment. Are we together? This is what it means. This principle, non-discrimination, both MFN as well as national treatment, kaput, gone. Why are they gone? I do not want to be making up things. Please, when you have a moment tonight, go to the USTR website. USTR website. United States Trade Representatives Office. You go there and search for the bilateral trade agreements the bilateral agreements of the United States in the area of trade. Search for that. Hello. If you are, okay. So, under the current administration of Donald Trump, the United States is not recognizing the principle of non-discrimination. The United States is entering into bilateral trade agreements with individual countries and charging them different duties on different products. Hello? This is not the question of the United States alone. Because the same countries that the US is entering into bilateral trade, including the EU, including China, including India, all of the big trading partners, they are also entering into those particular trading arrangements, and they're giving the US zero-rated duties in certain sectors, but they're not extending the same to the rest of the world. Are we together? I hope you can understand. Now, the foundation on which the AfCFTA is based, well, it's shaky. Because nobody, let me put it in these terms. The G20 countries are not respecting the WTO rules. All of them, no exception. All of them. The WTO is gone. That's why I'm saying it is in ICU. You know, when you watch those movies in ICU, they begin to be that beep. You see that? It is at that stage. We used to say the same thing about the WTO appellate body. And I'll end with the WTO appellate body. My brother. Ça va? The WTO appellate body. The US says, we're not going to allow for the appointment of another appellate body member. And that meant the appellate body cannot sit. Today, there's no appeals court at the WTO. It was in, we say, maybe they will consider, it was in ICU until they pulled the plug to say, so the WTO doesn't have an appellate body. What does that mean? It means that you can litigate against another country. So let's assume the microphone, back to it. So here's Lesotho. They then discriminate against the microphone from the United States, as an example. We treat it differently. The domestic tax on the microphone from the US in the domestic market is higher than for the domestic tax applicable to a locally manufactured microphone, right? And then the US takes Lesotho to the WTO dispute settlement system. It will go through the panel process. Maybe the US wins the case. And Lesotho wants to appeal. And there's no appeals court. Are we together? So today, if you take your case to the WTO, largely speaking, I'm putting that caveat because countries still do, largely speaking, it's just a waste of money because the case will likely be appealed. If it is appealed, it means that the verdict that would have been given by the lower panel system cannot be enforceable. What does that say about the MFN principle, the non-discrimination principle? Meaning that the principle is being defied at the level of the bilateral trade arrangements that these countries are entering into now. It's not a US issue. It's an issue of the G20 countries that are having these trade arrangements with the US. The European Union is beginning to say they need to deal with China on the overcapacity in terms of a lot of subsidies that the Chinese are providing. They forget also they were doing the same, and they still do the same somehow. Are we together? And they're thinking of introducing rules that can deal with China. And those rules will likely run against the principles and the rules of the World Trade Organization. And they are going to run against those particular principles. So, ladies and gentlemen, because over 40 members of African Union are also members of the WTO, and the AfCFTA is based on the WTO system that is under collapse. It is undergoing a collapse. It is. Some people don't want to believe it. I live in that. That system is in my blood. We who teach, when we say we teach international trade law, we teach the WTO law. I don't know what to teach now. If I go to class, and I did the other day, and I was telling students, MFN, I say, yeah, this is the principle of MFN, yeah, this is, I was like, guys, wake up, smell the coffee. Strong coffee from Ethiopia. Smell the coffee. This thing is gone. It is gone. Why? Because the countries that are supposed to protect it, none of them is protected. They just talk. Politicians, the WTO, preserve the multilateral trading system. There's a term we use. Everybody who's through this system will say this. The WTO needs to be protected, the multilateral trading system, with the WTO at its core. What WTO? Which rules are you talking about? Because everybody is now undercutting those rules, including African countries that are forced to enter into bilateral trade arrangements with these advanced countries. So he says I should end, and the end of it is this. Going back to where I started off from, you now see how business and commercial interests influence what you call international law. So it means that international law ceases to be valid if it no longer serves your economic interests. So I'll stop there, and thank you very much for your attention. It's certainly been a pleasure.
Thank you very much, Prof. Let us give him his flowers again, please. He has done very well. Excellent. Give me 5. Give me 5, Prof. Thank you very much. minutes. We have already gone above time, but we allowed one critical question, one critical comment, and that's it. Anyone who thinks they have a burning issue, then you can raise it. Otherwise, you can always send your emails and read the documents that have been recommended. I think this is very practical. You've really reached out, you've driven the elephant in the room. I see the appetite as, this appetite will never be satisfied. Aristotle said it, and he's still right. Yeah. So, Professor, we give you the flowers for the last time.